and in Baltimore, and as well good afternoon in Nairobi in Kenya. So my name is Ryan Orange with Miss Urbanova from the Quark Foundation. Today we'll have a match from day 3 of the Hague Inter-University Law Debate Tournament. So third match between the University of Nairobi and the University of Maryland. And I give the floor to my colleague for the introduction.
Thank you very much, and indeed, welcome and good day to the participants and, of course, observers, and also a big thank you to the 3 judges of this Day 3 debate. The topic teams received 7 days in advance is whether or not online platforms must implement safety by design measures consistent with international human rights law. Before we find out the positions, passing the floor to students for introductions, starting with University of Maryland, Ms. Fry.
Hello, my name is Abby Fry. I'm a first-year law student here at the University of Maryland, and I am one of the rebuttal speakers. Very happy to be able to be here with everyone today.
You're welcome. Mr. Kitty of University of Nairobi.
Hi everyone. Great to see you guys again. My name is Paul Kitui. I am a fourth-year law student at the University of Nairobi, and I look forward to interacting with everyone today. Thank you.
Thank you and welcome. From University of Maryland, Ms. White.
Hello, everyone. My name is Katie Ann White. I'm also a first-year law student at the University of Maryland, and I'm happy to be here.
Thank you. Welcome. From University of Nairobi, Ms. Barata.
Hello, everyone. My name is Jane Baraza. As well as Paul, I am a final year student here at the University of Nairobi, and I'm so honored to be here for the final group phase match. So thank you.
Thank you. Welcome. And of course, from University of Maryland, Mr. Givaramani.
Hi everyone, it's great to be here. Mimi ni shangwe, inatoka Amerikani. I have a lot of friends from Kenya and they are all super brilliant and articulate, so I'm very intimidated to be here, but also very grateful. I know that a lot has been going on, especially with, for example, flooding. So I hope also Mr. Ian feels better, and I hope that we have a very great match. Thank you so much for being here.
Welcome, everyone. So in a short moment, you should be able to see the wheel for the allocation of positions. And as we wait, also, we would like to give a shout out to the supporters for the 2 teams. And for University of Maryland, it's 2 past participants of the last year, so Mr. Hill and Ms. Liang. And on this moment, you should be able to see the screen, and there are 2 possibilities for each team. And we should find out in a second for which side will be represented by which team during the debate. So it will be the University of Nairobi's team that will argue in favor, and thus University of Maryland will be defending the against position. We'll be then starting with the University of Nairobi's opening statements. You now have 5 minutes to finalize your preparation. Thank you, everyone. Your time for final preparation has now passed. Just a short reminder, you will be getting visual cues during the debate. So yellow for 30 seconds and red for when your speaking time is up. Of course, you don't have to cut yourself short. Comfortably conclude your last sentence. All right, and thus without further ado, University of Nairobi, you have 4 minutes for your opening statement.
Right, thank you. I'll start on the count of 3. Sorry. Yeah, 3, 2, 1. Modern online platforms are not neutral communication tools for all parties involved. We have features such as algorithms or recommendation models and even virality features that allow for an asymmetry in terms of how people are impacted by social media. For instance, algorithms that reward outrage and polarization is very common. You have viral sharing tools that amplify misinformation. You have weak safety defaults that expose children and other vulnerable groups to a lot of online harm, misinformation, and perpetual problems. So, what does this mean then? It means then this connotes a systemic design flaw, and a systemic design flaw can only be fixed by a systemic approach. It means that these harms cannot be approached individually, which is the intuitive position that the opposition side is going to take in this debate. Just some concrete examples of how this happens. For example, the Rohingya persecution in Myanmar happened, where algorithmic amplifications of hate speech escalated violence in that regard. On to the legal part of the debate and what international human rights law says about the duty to protect individuals from online harm. We have most notably the case of KU versus Finland, held by the European Court of Human Rights, as well as the ICCPR Articles 19 and 17 that protect the freedoms of expression as well as privacy and family life, respectively. You also have the CRC Articles 19 that protects children from other abuse, and other vulnerable groups have, as well, have a protection that has a legal underpinning and thus legitimate in the world. What does this then mean in terms of our model? It means that we defend a regulatory requirement that online platforms incorporate the safety by design measures aligned with international human rights law. Concretely, this looks like age appropriate defaults, such as private accounts for minors. It means limits on algorithmic amplification of high risk content. It means friction before resharing potentially harmful material, as well as systemic risk assessments for recommender system. And we posit that these models must comply with universal principles of proportionality, transparency, necessity, due process, legality, and all of the above. The closest approach to this concretely will be a mirror of the European Union Digital Service Act, especially for very, very large platforms, as they are the closest example within which you can compare this. Before we get to our positive material, I would like to do some burden pushing to opposition. Opposition must defend a world where platforms continue deploying engagement-driven designs that foreseeably produce harm. Opposition also defend the burden of opposition also entirely falls on protecting individual users after the fact of moderation, as well as not applying the architectural choices that are designed to keep the private tech companies accountable despite their enormous societal power. On to the first argument then, and why systemic harms require systemic solutions, just low-hanging fruit. The largest harms emerge from design flaws in the systemic platforms. So you have examples such as the virality forwarding tools that accelerate misinformation. In our opinion, content moderation alone cannot solve this problem because it operates after the harm spreads, and that's a unique mechanism. This means that opposition leaves a system where platforms profit from harmful designs when relying on reactive moderation. The second argument that we'd like to give is intricately poke on the safety by safety design feature. One, we argue that it's a necessity as the UN guiding principles in KU versus Finland state that states must provide mechanism to address serious online abuse. Additionally, looking at the model intricately, it is often less restrictive and can counter mass censorship. I would like to end my
Thank you.
speech there. Thank you.
Thank you. Now passing the floor to University of Maryland for the against opening statements. 4 minutes.
Am I audible and visible?
Yes.
Okay, great. All right, I'll be starting in 3, 2, 1. Honorable judges, today's resolution has 2 key elements: online platforms and international human rights law. The pros theory is that connecting them via safety by design measures will help human rights law. This theory is false. The online platforms are self-interested and corrupt actors, and international human rights law is insufficient and only enables them. Combining these elements through safety by design, or SPD, will only worsen existing issues with internet safety. Today's topic is vital. Though we disagree with their method, the pro has listed real harms, which we too want to resolve. We simply argue that alternate visions, more seriously and realistically committed to online safety, must be considered. Our first contention is that online platforms themselves cannot be trusted as regulatory actors. As property law experts explained for the European Law Journal in 2023, SPD measures facilitate an indivisible handshake with tech companies that trades actual regulations and public accountability for cost-saving self-regulation half measures. Simply put, the pros model prioritizes tech companies' profit over effective harm reduction. SPD cost-saving measures manifest in several ways. For one, online platforms often opt for algorithmic content moderation rather than manual. This results in automatic overproducing that restricts legitimate speech online, giving platforms closely aligned with state interests plausible deniability as they deploy algorithms to silence dissent speech. Beyond algorithms, online platforms also rely on private arbitration systems, tilted against users. Facebook Oversight Board, for example, has widely criticized for advancing companies' interests and keeping online safety issues outside of public courts. This is the world that the pro advocates for, a world where public safety issues are kept out of public courts. Judges, we need actual regulation, actual liability regimes that can be litigated in public court, not corporate-friendly safety by design measures. Our second contention is that international human rights law is too weak to serve as the only legal framework for online safety. For one, these are too soft instruments contested with unstable legal concepts. The UN Guiding Principles on Human Rights establish a framework for businesses to commit to human rights, but the guideline has no enforcement mechanisms, and even companies that have signed on to them still routinely violate the UNGPs. More warningly, human rights law is rife with nebulous exceptions that will allow states and online platforms to restrict fundamental rights, such as speech and religious expressions. ICCPR Article 19, for example, allows speech restrictions when necessary for national security, public order, or even public morals. But as we can see in the SAS versus France case in 2014, the court upheld the ban on head coverings. This thus, not only are platforms not trustworthy as safe regulators, the pro will only be applying weak, unenforceable, and nebulous legal framework with exceptions ready to be abused by states. If we are to take online safety seriously, we must pursue actual solutions rather than comfortable fantasies. Thank you.
Thank you very much. We'll now hear the first rebuttal, University of Nairobi. You have 2 minutes.
Thank you. I'll be starting my speech in 3, 2, 1. The problem in this particular motion is not whether platform should adhere with international human rights or not. The question is whether the models that these platforms tend to take up should have safety by design models or they should have alternative models. So the motion that we're trying to propose in this particular debate is that we from Team Proposition, we're trying to advocate for a preventative mechanism that is able to address these problems rather than having a reaction to it. First speaker from Team Opposition has stated that international human rights are quite insufficient in dealing with the problem. But them making this assertion creates a problem, or rather a legal lacuna, as to what then gets to dictate how these particular platforms should be able to be regulated. In fact, when they say that international human rights is insufficient, it then makes us question, then what mechanisms can be used to safeguard those who are able to ascribe to these particular mechanisms? That has gone unanswered by the first speaker from Team Opposition. But most importantly, just to reiterate what my first speaker from Proposition clearly stated, it is more about being able to safeguard how online users are able to be protected when using these platforms as compared to waiting for the harm to have occurred. And most importantly, safety by design mechanisms are able to adhere to international human rights principles. Namely, firstly, Article 12 of the Universal Declaration of Human Rights, which talks about protection of privacy. Article 19, protection of expression. And we do not entirely agree with the framing that has been set up by Team Opposition, whereby they say that these mechanisms might be able to limit free speech. Instead, we believe by safety by design, these platforms are able to be sufficiently guided by already established precedent and only limit what is necessary and what is legitimate in this particular instance. Thank you.
Thank you. For the first rebuttal, Deacon's position, University of Maryland.
Am I audible and visible?
Yes.
Okay, thank you. I will start in 3, 2, 1. So the pro recently mentioned a preventative mechanism, but what we want companies to prevent through SBD is not the only thing they will prevent. The ICCPR, International Covenant on Civil and Political Rights, which both of our opponents most recently cited, adopted by the UN General Assembly in 1966, actually states that the freedom of expression can be restricted on the basis such as national security, public order, or even public morals. And all of these are incredibly easy for governments to manipulatively construe. This January, the UN's top human rights official, High Commissioner Volker Turk, raised alarm over what he described as the growing dehumanization of migrants in the United States, warning that current immigration enforcement practices are undermining due process and basic human dignity. Meanwhile, this February, employees from Google, Meta, and Reddit all anonymously disclosed that their companies had received hundreds of administrative subpoenas from the Department of Homeland Security to share their names, emails, phone numbers, and more private data behind social media accounts that track or criticize ICE. Despite widespread humanitarian concerns, no doubt the US government would like to cite Article 19's public morals or national security exceptions for free expression. Employees stated their companies complied with some of the subpoenas, giving away some users' private information. But if these companies had to implement SBD, it's safe to say that this entire process would be complete and automatic, making the sum become all. President Trump went hard on TikTok, for example, when it didn't favor him. But now that he made his deal, we've seen users reporting increased difficulty in posting pro-Palestine or anti-ICE content. This is American safety by design. And America is significant because merely one American company, Meta, whose CEO is also close with President Trump, has the majority of global social media market share. The pro refers to systemic flaws. SBD in the current dismal human rights landscape will only deepen these flaws. And that is exactly why, as opposed to allowing companies to be in cahoots with governments that ultimately exacerbate the flaws, we should endorse a real way that public safety can be accounted for with public liability in public courts.
Thank you. Passing the floor to University of Nairobi, 2 minutes.
Okay, so I'll mostly engage with the immediate former speech. So we get a very articulate breakdown of how you make ordinary users susceptible to an exacerbated form of government access to personal data and things of the sort. So two responses. Firstly, even if that was true, and let's take your argument to be entirely true, we have to weigh the veracity of what we are defending. On our side, we offer more palpable and proximate harms. So lives are being lost. there's a lot of harm that's being realized. Children are already at harm. And by not applying this model, you're just letting big tech companies and companies that run a monopoly on government services exacerbate the harms that they're already doing. This model may be imperfect, but at the very least, it has taken a step towards advancing, addressing issues that continuously affect disenfranchised groups who the system can otherwise not have an incentive to fight for. Whatever harms you've cited are easily correctable. There are numerous statutory provisions that address these. They may not be as extensive, but there is growing jurisprudence on the same to address this. There are growing Supreme Court rulings by the United States and other dominant jurisdictions across the world. The EU most prevalent and the crackdowns they've made on big tech, such as Meta and all of Meta's subsidiaries. The bottom line is on our side, the harm is palpable. There has been no redress to these harms over an extended period of time. While we do appreciate your citing of some possible existing harms, one, they are not as egregious and don't carry as much veracity as what we are trying to prevent. But even secondly, the harms that you do cite are more easily correctable through complementary legal frameworks. I would like to end my speech there. Thank you.
Thank you. Passing to University of Maryland. 2 minutes.
1 second, just getting my timer up here. All right, I will begin in 3, 2, 1. First, I want to clarify the burden in today's debate. At the very first speech, the affirmative stated that we have to defend engagement algorithmic tools. That's a false burden. We are not assigned an affirmative burden if we are on the negative. We just have to simply prove that safety by design is not the best option in today's debate. And I believe we have done that through 2 reasons. First, we see that issues with safety by design are inevitable. If we use algorithmic tools, which will eventually fail or have some mistake, there needs to be redress. And mostly that will happen through arbitration. We stated within our constructive speech that the Facebook Oversight Board and other social media boards are tilted against users. So when they bring these concerns, Facebook is just going to defend their self-interest. So it's actually not protecting people in the long term if when they're trying to actually make sure that these enforcement measures protect people fail, because social media companies work in self-interest. Also, just because safety by design is implemented doesn't mean it's going to be done well. Social media companies or online platforms just might meet the bare minimum as we see if they aren't actually enforcing safety by design or caring about it. The benefits that the affirmative bring up in today's debate fail. They're also handing the power of regulation to social media companies. So if the social media companies themselves don't see a benefit to themselves financially to enforce safety by design, they're not going to. Then we also see that what they say that human rights law is going to be upheld actually won't. We look at SASV France, which they stated in their constructive Article 19. We see that Article 19 has a loophole. If states see that safety by design is actually hurting their interests, they're going to exploit these loopholes within international human rights laws. States will act in self-interest, and so will online platforms, and therefore safety by design is not the correct option to go with in today's debate, and therefore we ask for a negative. Thank you.
Thank you. We'll now hear the concluding statements for the in favor position. 2 minutes.
In 3, 2, 1. I'll disagree with the last speaker from Team Opposition by saying that all they have to do is show why safety by design is bad. It is imperative that they also engage on what the alternative would be. And as you have presented, we've been able to mention that the alternative means that you're trying to push the burden on vulnerable users, children, women who are more likely to be targeted by misogynistic abuse posts or even gender-based violence posts, which are definitely going to allow most platforms to capitalize on it if it especially like boosts their their engagement metrics, right? So in this particular debate, it is imperative for us to understand if you're not able to prevent the harm before it occurs, we have to deal with the imperative, or like we have to deal with the problem where people have already been exposed to harm, and the impact, or rather the response that you're able to get from it, is not sufficient. And most importantly, we'd like to also mention the case of Delphi AS versus Estonia 2015 before the European Court of Human Rights. This particular case was it's the best way to reflect how most platforms, they can be sluggard, especially when it comes to responding to already existent harm. But again, secondly, that already, it constantly, or rather it easily depicts why, if you're not able to prevent the harm from occurring, what dangers it then exposes those who are within your platform, those who are the most vulnerable users, the minorities, the children who cannot essentially protect themselves, the danger that they get exposed to. Hence, through safety by design, we're able to protect these particular individuals from being able to experience the harsh mechanism when it comes to international law. And most importantly, we're not allowing these particular platforms to just do the bare minimum. As the motion suggests, you're adhering to international human rights, right? So things like privacy, expression, these are the best guiding mechanisms as compared to just asserting that these platforms will just do the bare minimum. Thank you.
Thank you. For closing remarks in the against position, 2 minutes.
I want to go over the burden in today's debate again. We do not have an affirmative burden as the negative. We simply have to prove that safety by design will make what we are experiencing worse. And we believe that we have done that in today's debate for 2 reasons. First, we're going to look at solvency in today's debate. The affirmative has not given you one concrete example of how safety by design has worked in the past. When they speak in theory, when they speak in will this happen, this doesn't mean that it actually will solve anything. Just stating that these harms exist and this may solve it doesn't mean that it will. They're not addressing the harms. They are just simply restating the harms that currently exist in the status quo. And because they can't provide solvency in today's debate, we advocate for a vote in the negative. We also see that even if these tools are employed in the future, which we haven't seen that they will be or have been at this point, when there's weak enforcement mechanisms, first, because arbitration has failed in the past, and secondly, that the actors that are actually regulating this are going to work in self-interest and not in the interests of the people, we see that safety by design fails. First, when you give regulatory power to social media companies, they're only going to act in their self-interest. We see this with the Facebook Oversight Board. When issues of safety were brought up to Facebook, they tilted the rulings in favor of themselves. And we're going to see this with all online platforms. We also look through SAS v. France, which stated that states are allowed to violate freedom of expression and freedom of speech if it's in national security or public morals of that favor. So yet again, when states and online platforms both know the loopholes to get around safety by design, the benefits that the affirmative have brought up in today's debate are simply not going to manifest. And because we're actually going to see no change and we're going to see a limitation on speech, we strongly ask for a negative vote. Thank you.
Thank you very much. This concludes your Day 3 debate of the Hague University Law Debate Amendment 2026. Well done to your teams. And just as a note, it is actually the 3rd Day 3 debate of this round. So you have a good number for 3. You can all relax. You're no longer under evaluation after this part. The evaluation judges, do you have the time to review and submit the scoring cards? But already now I would like to invite you to share your experiences, either during the research or your experience during the debate itself, if you heard something familiar from your own research, or perhaps if your coursework already prepared you for the research for this debate. Starting with University of Maryland, Ms. White.
I found this debate very informative. I found the topic, just like our other topics in previous debates, to be very thought-invoking. I have never really thought about safety by design standards or the regulations that online platforms are implementing. So I was actually grateful to get this topic so that I could actually think about that. I found the debate today to be actually, I think it was well debated from both sides, and yeah.
Thank you. From University of Nairobi, Mr. Kitui.
Yeah, without sounding redundant, it was a great debate. The topic was particularly great because it touches on an everyday phenomenon that we mostly get surface level bite-sized information on. So maybe going a step further and looking at what some of the implications are legally was definitely something very informative. So I enjoyed a lot of the submissions from the other side as well. I would say particularly this one, um, I enjoyed it just from the perspective of learning more and hearing about what the other teams had to say about it. Because of all the three motions we've done, I think this is the most proximate one because we engage with the algorithms every day. We doom scroll, we do all of those things. So yeah, definitely.
Ms. Fry of University of Maryland.
I mostly did research on the affirmative topic aside of the debate, so it was interesting to have to rapidly adapt to the negative or the con. But this was probably the debate that I heard the most amount of like international arbitration or international court cases cited. So that was interesting to hear the different ones. I also think this is a very relevant topic. I mean, we're on an online platform right now. Everything we do basically has to do with the internet these days. I'm trying to reduce my screen time. I'm not doing super well at it, but I'm trying. So yeah, great debate, everyone. Thank you.
Thank you. Ms. Barata.
Thank you. So for this particular motion, it was quite interesting, especially given the fact that we have constantly been interacting with different platforms and we see these different regulatory mechanisms that exist. But I couldn't really classify whether it was a safety by design or whether it was a regulatory reactive mechanism up until I started looking or rather researching for this particular motion. And it's been really insightful, particularly given the fact that we are all engaging in a huge platform where people have different perspectives, we have people with different views on things that are controversial or not, and getting to classify whether it should be regulated and how it should be regulated. I think that was a really insightful mechanism for management. So yeah, this motion was really nice.
Thank you. Mr. Kivaramani.
I'll be honest, I think everybody already said the majority of my thoughts. But it was really fun, and I enjoyed the back and forth.
Thank you. So usually we wrap up the debate session with a bit of networking, but perhaps now, because it is a day 3 and it's the end of the group phase, we would like to give you the space if you would like to give a shout out to anyone who motivated you, encouraged you, or otherwise supported you during the group phase, day 1 to day 3, perhaps even the opposing teams that motivated you for the next steps, your faculty or your coaches. So first, passing the floor to University of Nairobi's team.
Yeah, so it's been quite the run. I think I've enjoyed every single step of it, interacting with each and every one of you. So the hosts, it's always great to see you guys. New opponents every round. Yeah, and it's been great, learning about different places, what you guys sort of do. I remember the first session we were asked to say something unique about our cities and where guys should visit, um, which was pretty interesting. By the way, just as a side note, I'll probably message you guys on LinkedIn. Uh, you guys are in Maryland. I think I'll be in DC next week, end of next week. So I know that's pretty close to Maryland. If you guys are down, we'll probably do something because I'm there for quite a bit. So yeah, hopefully I'll see you guys there. But otherwise, thanks to the faculty and everyone that made this debate possible. So thanks.
Well, if there's anyone you would like to give a shout out to, that supported you and motivated you as you were going through group phase?
Yeah, of course. I would like to give a shout out to my team, that is Paul and Ian in absentia. I think, given the fact that we are friends, we've worked together, we are classmates, we've coached ourselves, and having to got to this particular point, it has been quite. It's been something meaningful, honestly, and the fact that we get to learn more about one another and we get to learn with one another and grow with one another during such opportunities. I think my shout out would go to my partners, and I'm really glad to have done it with the two of you. Yeah.
Okay. And question for University of Maryland's team?
I guess we can shout out our 3 coaches. Amanda, Josh, and Leanna been really great supporting us through this, both like personally and professionally, and learning how to adapt to this style of debate. So it's been a really great season, even if we don't advance, knock on wood. But yeah, those are my shout outs. And also to also to my teammates. We have a Alex, Katie, and Sean. Even though they're in the room with me right here, I just want to give them a shout out myself. So yay.
I guess I'll add on to that. Shout out to our coaches and also my teammates. I found it very delightful, I guess. We have so many different personalities, but we were able to collaborate and draft the pros and the cons for each debate. So that was very good. Also, to our opposing team, if you guys are here in DC, if you like museums, I'm a great museum tour guide, for DC. So if you guys do message us on LinkedIn, or me on LinkedIn, I could give you a great tour of DC if museums are your vibe. Yeah, thank you.
Yeah, I don't have LinkedIn, Paul, but if you message either of my teammates, yeah, I'll love to exchange WhatsApps. Yeah, shout out to the coaches. Shout out to our research head, Alex. Shout out to last week Saudi Arabia. They were really fierce. As were you all. So I really like having these awesome opponents who inspire me to try to train better. And then also shout out to my friends, Collins Munene Karaoke and Russell Omo Shotieno. They were these CS majors who talked to me a good amount about tech just over my life, and they also happened to be from Nairobi area. So yeah, that also inspired me.
I see you. Perhaps you have a good opportunity to meet in person. Do not hesitate to send us a picture so we can reshare. Over the years, it's been a pleasure of the organizing team to see the teams meet in person. And of course, if you have a chance for the final week in The Hague, which will be happening in the week of 12th of June, you're all more than welcome. We are planning some activities also in hybrid, so virtual connection is encouraged as well. And of course, in soon to be mid-edition break in April, you will have an opportunity to network and interact with other teams from other groups as well. And a final question before we wrap up for today. Over the course of group phase day 1 to day 3, but of course also during your studies and perhaps personal motivations, what would you say are the areas of law or perhaps organizations or countries' legal systems that you are inspired or encouraging or find encouraging to learn a bit more about or to participate in professionally as we go? So perhaps passing this time first to University of Maryland.
For me, through my studies, I want to become an immigration attorney. It's a really serious issue in the United States at the moment. And I feel like people should not be defined on where they're born, where their family is from. Humanity should not be limited by borders. I think that's one reason why I really like this form of debate, being able to debate with people and interact with people all over the world, because you don't get that opportunity all the time. Um, yeah, so that's what I don't know if I'm inspired by the state of our country as it is right now, but I'm encouraged by the ability to help make a change and to help people, I guess.
I think something notable on my end has been all of the exceptions that we see in human rights law. And that's been sort of depressing to me, but it's also made me want to study it further to try to see how we might be able to change it over time. It's unfortunate that it's very nebulous and gradualistic, but I think that it's a obviously a pertinent problem, especially in each of the great powers. Um, so yeah, that's something that I want to look into more.
I think for me, I have some interest in international law, and I found that this debate helped to open my mind up to the kind of laws that are already in practice. Also, just like the connectivity between the EU and the UN and the loopholes that do exist. I do have some interest in learning French law as well. Je parle un peu français. So I would like to, learn a little bit more about how international law operates. And I found that this debate gave me that foundation for that. So just wanted to thank you.
Thank you. Thank you for sharing. It's quite inspiring. And same for University of Nairobi. What area of law or perhaps country's legal system do you find interesting to look into more?
Yeah, so definitely pretty similar to some of what has been said. So like public international law is pretty fun. It's been great, digging into various treaties like the Vienna Convention and all of them. It's been fun. Also international commercial arbitration as well. This may be biased to a moot court I did last year that had me dig extensively to the topic. So maybe I'm still biased to that, but it's definitely my scope has been widened by everything we've done, from this experience. So yeah, somewhere around there. It's not definitive, but maybe we'll figure it out within the next few months or something when I really have to pick one. So no pressure.
Well, for me, I would say I really am intrigued to learn more about international economical law, and that is tracing back to the first push that we did with regards to shared commons. I think getting to understand the disparity between developed and developing states, what decisions, what influences how certain decisions are made, how funds are distributed, the impacts that it then has, or even like the transboundary impact that are then materialized in such situations. So I think getting to learn how we're able to navigate and how the existing systems are able to influence or mitigate certain effects that already happen. So yeah, I think learning more about shared commons and mainly international economical law. Yeah.
Yes, go ahead, Mr. Kilaramani.
Thank you so much. Wait, Jane, I wanted to mention I have a friend who leads this program. Pretty related to what you were saying. It's like scholars in Kenya can assess Chinese law with regards to economic development. So if you're interested in that, then maybe reach out to one of my colleagues, and then they might pass it to me. Yeah, thanks.
All right. Then we won't keep you much more from the networking amongst yourselves. See you for the next step during the mid-edition group break for the networking activity. I'm passing the floor to Professor Laurent to close us off.
Yes, it was a great match. So again, congratulations. And of course, I mean, if you want next year to participate in French, you're welcome. So I hear some people are learning French. We have already one student this year who participated last year in French who is now in English. So from a Canadian university. So if you want to indeed debate in French, of course, we are welcome to see for next year. As well, if you want to visit this year, if you cannot, you can visit us next year. And we have as well some students. We got already Miss Feinlib that you know in Maryland who came last year. So we actually have an invitation on multiple years if you want to visit us in The Hague, not just a few weeks after. So voila. So congratulations again, and we keep in touch, and soon you will get the results for this match. So thank you again. Bye bye. Bye bye. Thank
Well
you.
then, goodbye.